Hi, I'm Steve Vest, and I'm the host of FPB's Meet the Candidates. This Cable 10 series allows you, the voter, to hear directly from the candidate on views on the issues that are important to us. This is leading up to the general election on November 5th. Today's guest is Judge Pamela Goodwine, a candidate for the Kentucky Supreme Court 5th District.
Correct.
I'd like to thank you for coming by to visit, and if you would, could you please tell us about yourself?
Thank you, Steve. Yes, I'm Judge Pamela Goodwine, and I currently serve the citizens of Frankfort, Franklin County, as well as 7 other counties, Bourbon, Clark, Fayette, Franklin, Jessamine, Madison, Scott, and Woodford, but work on the Kentucky Court of Appeals as well as the Kentucky Supreme Court. Serves all Kentuckians, not just the 5th Appellate District. Now, I've been a judge for 25 years, serving first as a district court judge, 4 years in Fayette County. Following that, I was a circuit court judge for 15 years, where I tried vast amount of cases, various subject matters. Probably tried more cases than any other judge in the 5th Appellate District during that period of time. I, in 2018, then became a Court of Appeals judge, where I've served for the past 6 years.
Okay.
In addition to the general qualifications for being a justice on the Kentucky Supreme Court, I think that serving as a judge at every level of the judiciary in Kentucky is very, very important, because it has given me a vast array of experiences and knowledge that I believe is needed for the Kentucky Supreme Court. I had wanted to be a judge since I was a teenager.
Yeah.
Growing up in the inner city of Youngstown, Ohio. And I recall when I was a junior in high school, walking into the Mahoning County Courthouse in Youngstown and not seeing anyone who looked like me.
Yeah.
And I wanted to change that. I wanted to be a beacon of hope for others who looked like me growing up in the inner city. And I went home, I told my parents, I said, there's no African Americans or women in the courthouse, and I want to make a difference. I want to change that.
Right.
I grew up in the middle 60s. Thurgood Marshall was an idol of mine, and I wanted to emulate someone like that in making a difference. And I graduated valedictorian of my high school class with a full ride scholarship. I chose Carnegie Mellon. However, I didn't get to use that scholarship. By the age of 19, I had lost both my parents to tragedy. My father first to lung cancer, and forfeited that college scholarship and enrolled at ITT Tech, went to technical school to become a court reporter. Mm-hmm. Graduated in November of '79, and I got a phone call from Lexington, Kentucky, which is how I got to Lexington.
Right. And
moved to Lexington to start my career in the legal profession at 19 as a court stenographer. Traveled all over Kentucky, was in various courtrooms throughout Kentucky. A wonderful career. Was here 6 months when my mother was murdered. I knew then that I was on the right career path to become a judge, to make a difference in the lives of many. I've seen how legal decisions impact communities, impact people's lives. And I think it's very, very important to remember that. And being the only candidate in this race who has that vast array of experiences, who has been a judge for the past 25 years, I believe, makes me the best candidate for this position.
Well, regardless of race, I mean, going from being a court reporter to a judge,
Absolutely.
That's a little unusual.
Absolutely.
Okay.
Absolutely.
Well, outside of being a judge and your career, tell us a little bit about yourself.
Well, outside of being a judge, a lot of people call me the jazzercise judge. I do believe in fitness, and in 2011, I discovered jazzercise. I loved it. They said the motto of jazzercise, it says, "Take it, love it, teach it." And I took it, I loved it, and wanted to then learn how to teach it. And I was in the middle of a capital case, a death penalty case, when I, after court, drove to Cincinnati to audition. It's a national audition in Cincinnati, Ohio. And I went up there and I thought, I'm going to dance my heart out for this audition. And I didn't make it. I wasn't certified. In fact, the instructor said, "Who told you you could do this?" And I thought, does she know who I am? You know, I'm a judge. However, that didn't deter me. I thought, nobody tells me what I can't do.
Right.
And I came back and I worked hard. I studied. I practiced and practiced. And on my 52nd birthday, in June of 2012, I went back to Cincinnati. I auditioned and was certified to become a national jazzercise fitness instructor. And I've been teaching at 5:30 a.m. Since then. Now, when I filed to run, I took a leave of absence from jazzercise, from teaching. But it's the way that I relieve stress.
Yeah.
I'm married. I've been married for 24 years now. We've been together 25 years. We have 2 children and several grandchildren, now working on great-grandchildren.
Yeah.
And love every bit of that.
Okay.
It's wonderful.
Well, great. So what role, if any, do you believe your background or personal experiences play in your approach to the law and judicial decision-making?
I believe the vast experiences that I have had, the obstacles, the tragedies, and everything, has given me a certain compassion for those who come before me. Growing up in the inner city, being lower middle class, being raised by 2 people who took me in, I was placed in their care, foster care. They adopted me, but taught me that what a strong work ethic and what values a strong faith meant, that I had to work hard for everything that I wanted. And because of that, when I am in the courtroom, I believe everyone is accountable. Everyone must be accountable for the decisions they make, for the choices that they make. I think that is vitally important. And when someone comes also into my courtroom, I believe that they are entitled to respect. They should be treated with respect. Most defendants want to be heard. They want their voices heard. And I believe that I bring that. I believe that my experiences have allowed me to show that compassion, but also be fair, be tough, because I didn't let circumstances define me, nor do I think that circumstances should define anyone else. I believe that they should all be held accountable.
Okay, so is that your judicial philosophy as well? I mean, or could you describe your judicial philosophy?
Well, and judicial philosophies are defined in different ways, and sometimes it's confused with political philosophies.
Yeah,
you know, political philosophies are couched in terms of whether you're liberal or conservative. Judicial philosophies can be couched in terms of whether you're an activist or you exercise restraint, whether you believe in strict construction of the Constitution or a more loose construction of the Constitution, whether you believe it's a living document or whether you believe in the original terms and intent of the Constitution. I believe the Constitution is one of our most sacred documents. I also believe, though, that our founders knew best, and they put provisions in the Constitution to allow for its amendment. So I like to think of myself more in terms of a Justice Breyer, who believed in a pragmatic approach to interpretation. When judges are faced with a situation, particularly constitutional interpretation or statutory interpretation, they must first look to the language of the document and whether or not there's any ambiguity. If there is ambiguity, then we must look beyond the terms and determine either what the intent was, what its impact is, and what effect it's going to have. So I like to think that my judicial philosophy is one of a pragmatic approach.
Okay. Can you provide an example of a Kentucky Supreme Court decision that you agree with and why? And conversely, one that you don't agree with and why?
Well, I think that's perhaps getting into an area that maybe we can't really talk about, in the sense that if it's current Supreme Court precedent, if that issue may come up before the court again, if I'm on this Kentucky Supreme Court, then I will have to address that issue. If I express a concern now of whether I agree with it or not agree with it, then someone may say, well, maybe she should recuse herself from that case and not discuss that case. So
Okay.
I think that may be something that I shouldn't get into with specifics.
Okay. Well, what factors do you consider most important when making a decision on a case?
First of all, I think that the role of a judge is to apply the law fairly and administer justice consistently. So what I have to look at when I get a case before me, I have to look at the facts. I look at the facts, and then I look at the arguments, and then I have to apply the law to those facts.
Mm-hmm.
That's about as simple as it can get.
Right.
Now, is it always that simple? No, it's not always that simple, because the arguments for or against a particular issue may not be crystal clear. There may be gray areas. There may be issues that the legislature didn't think through when they wrote or enacted a particular bill. And so when the courts are asked to interpret that particular statute or that particular legislation, then we have to, again, look at our judicial philosophies and determine, how is this going to impact society? How is this particular law or this particular statute, what was its original intent? As written, can that intent be implemented? Or what impact is it going to have on society?
Mm-hmm.
And so all of those things come into play when interpreting a particular case. Now, what I can share with you is a particular instance. When I was on the circuit court bench, I had a case that came to me that had to do with derivative actions. And there were two competing statutes that were currently on the books that said exactly the opposite. So one side argued one statute, of course,
Yeah.
and one side argued the other. And basically, the legislative history of all of that was, we'll let the courts figure it out.
Right.
Well, our role as judges is to interpret the law. The legislator's jobs is to write the law. Sometimes they don't write it so that it can be interpreted one way or the other. In fact, in that particular situation, we had two competing statutes that would have been interpreted completely the opposite. So both sides argued their respective version of the statute, which was very, very difficult, but I had to make a call, and I made the call.
Mm-hmm.
But again, sometimes when laws are written, they're not as clear, nor are they thought through to their logical conclusion, and the impact and the effect of those laws are sometimes not foreseen. And the role of the judge is then to determine whether or not it's constitutional, and if it's not constitutional, then to call it so,
Right.
and to rule that it's not constitutional.
Yep. Okay. Well, how do you ensure that your personal beliefs or your biases don't affect decisions that you make on the bench?
Well, again, my 25 years experience on the bench has certainly helped me in that regard. I have had to make some tough decisions. I have had to interpret laws that I absolutely, totally disagreed with. But there was no ambiguity in that particular law.
Right.
And I ruled accordingly. So one, I've learned over the course of the 25 years how to set aside my personal beliefs, how to set aside my differences. On the Court of Appeals, we serve in 3-judge panels. So unlike on the circuit bench where it was just me,
Yeah.
and I got to call it a ball or a strike, on the Court of Appeals, we work in panels of 3. And so 2 of the 3 must agree. for a decision to become a majority opinion. Meaning I have to talk through my beliefs, whether they're biases or beliefs or my personal thoughts on interpreting a particular case. On the Kentucky Supreme Court, that panel of 3 is expanded to 7.
Right.
So the 7 of us will meet in conference and discuss a particular case. If I disagree with the majority, or if I disagree with the author, I can then write a dissent and explain why I disagree with the author of the opinion. I may concur, but for a different reason, and can then express what the reasons are why I agree or disagree. So I think it helps, one, to serve on either a panel of 3 or on the Supreme Court in banc, all 7 of us, versus being on the circuit bench when it was just me making a decision. I had to rely on the appellate court process to determine whether I was right or wrong. And I've been very, very fortunate and very proud of my record on appeal, that over 85% and closer to 90% of my opinions have been upheld on appeal.
Okay.
And both from the circuit court bench and while on the Kentucky Court of Appeals. Now, there are specific situations that are outlined in the Judicial Code of Conduct that dictates when a judge or justice must recuse themselves from a particular case. And if I find myself in a situation like that where I either have, for whatever reason, a particular interest in an outcome of a case or a relationship with one of the parties that would impede my ability to be impartial, then it's my duty and my job to step down and recuse myself from that case.
Right.
As dictated and mandated by the Kentucky Code of Judicial Conduct.
Okay. Well, what do you see as the most significant legal issue currently facing the Kentucky Supreme Court?
Well, I think there are a lot of legal issues that are currently facing the Kentucky Supreme Court. There are a lot of social issues that are confronting our nation. A lot of those issues have spilled over in Kentucky, and we would all be remiss if we denied the fact that they exist. They do exist. And I'm quite certain that those decisions will have to be made once I'm on the court, and I look forward to working with my fellow justices and helping to resolve some of those issues.
Okay. Well, speaking of that, spilling over, can you talk about the role of ethics and judicial conduct in maintaining public trust in the judiciary?
Absolutely. And as I mentioned, our Supreme Court has issued what they call the Code of Judicial Conduct. Within the Code of Judicial Conduct, it spells out behaviors that judges and justices must live by and must abide by, both in their personal lives and in their professional lives. It's spelled out in the rules, and it talks about what funding we can receive, what gifts, reimbursements, or anything like that we can receive. It also talks about what we can and cannot do to maintain the integrity of the judiciary and to maintain the integrity of the court. And I think it's important, one, and I've got it sitting on my desk. Mm-hmm. Not only it doesn't just deal with elections, it deals with our day-to-day lives and our day-to-day functionings within the community. It talks about the limits on contributions. It talks about the limits on gifts. I will ensure and absolutely commit to living by the Code of Judicial Conduct, and have for the past 25 years. And I'm very, very proud of that record.
Okay. Well, the next question was basically what you just said. So what do you believe the role of the judiciary is in safeguarding democracy and the rule of law?
Yeah. Well, as I indicated, the role of judges, again, is to interpret the law fairly and to administer justice consistently. Now, those two things are very, very important. Administer justice consistently. That means that justice is for all, that the law should apply to everyone equally, and everyone should feel like the justice system is there for them, not just a select few, not just those who are of a certain class, but for everyone. I am proud to say that I have been a judge for everyone, and that I am prepared to serve as a justice and for justice for all. I think that is very, very important to know, to understand, and that everyone believes that the judicial system works for them.
Okay. Could you talk about transparency in the judicial process, including the use of cameras in the courtroom?
I do believe it's important for transparency, that cameras can be in the courtroom. I welcomed that on the circuit court bench. We welcome it for our oral arguments at the Court of Appeals. But it's a little bit different on the Court of Appeals because the presiding judge gets to determine that. When I'm the presiding judge, we have them. On the circuit court bench, I had cameras in the courtroom. We record our proceedings, and they're open to the public. Now, obviously, cases that involved or that the media believed were high-profile cases, they could actually have a camera in the courtroom in addition to the cameras that are already in the courtroom.
Mm-hmm.
On the Supreme Court, again, oral arguments are generally open to the public. They are live streamed, so anyone could watch them. I believe that that's important for transparency. But in addition to courtroom transparency or case transparency, I think it's also important for judges to be transparent and the justices to be transparent. And every year on March 15th, justices and judges have to file a financial disclosure. That's something that's written into the Code of Judicial Conduct. So that is expected. That's for transparency purposes. And why is that? That disclosure is necessary because it identifies whether or not, if there's a company or an issue that may come before the court, and I have a financial interest in that particular company, then obviously it would behoove me to recuse from that particular case. So I think transparency in the court system, in the courtroom, and with cases is very, very important.
Okay. How would you work to improve efficiency in the court system?
That's something that I've been working on at every level of the judiciary that I have been a part of. I was chief judge in the Fayette District Court. I was chief judge in the Fayette Circuit Court, and I'm deputy chief judge of the Kentucky Court of Appeals. And at each level, I worked to improve efficiency. I did that on the Court of Appeals by chairing the pre-hearing conference committee, and actually worked to revamp that entire process because cases were getting bogged down within the pre-hearing conference context and getting stuck there, maybe 18 months, sometimes 2 years. And what I did was recognized, one, that that's where the problem was, and then offered a solution about if attorneys believed a case could be resolved at the pre-hearing conference level, put the onus on them to file a motion rather than just say every case has to go through that process.
Right.
If they didn't want it, they don't file a motion, it doesn't have to go through that process. We're looking now at even, rather than having all attorneys file pre-hearing conferences in every case, to simply file one in the cases in which they're going to have or ask for a pre-hearing conference. That has cut the time almost in half.
Okay.
And what I would do on the Kentucky Supreme Court is also look at any areas in which efficiency could be improved. One thing we're doing is implementing e-filing, which has helped tremendously with all cases. It was just a pilot project a few years ago. Now it's going to be mandatory in all civil cases.
Okay. Well, this one you could group with addressing the audience at home if you want to, but how are you uniquely qualified for this position opposed to your opponent?
Several ways. I'm a judge. I've been a judge for the past 25 years. My opponent has never been a judge. In addition to having a Juris Doctorate, I also have my Master of Laws degree. In 2020, I was nominated for the Intensive Master of Laws program at Duke University by then Chief Justice John Minton. And I believe that that was a wonderful opportunity for me to learn from federal judges, from Supreme Court justices, to help hone my skills, to prepare me for being a justice on the Kentucky Supreme Court. I graduated in May of 2023. I didn't realize how perfect that timing was going to be, having filed to run for this particular seat in November of 2023.
Okay.
But that is what separates me from my opponent. I was a judge when my opponent was in law school and had been for 6 years. And I believe it is vitally important to the constituents of the Commonwealth of Kentucky that they have the best qualified person for this position. Kentucky's highest court is not a place to begin a judicial career.
Okay.
So that is why I believe that makes me the most qualified candidate for this position.
All right. Well, you get a chance to look right into the camera and address our viewers and ask them for your vote.
Thank you. I am Judge Pamela Goodwine, and I am on the ballot in November. I will be on the ballot in 8 Kentucky counties: Bourbon, Clark, Fayette, Franklin, Jessamine, Madison, Scott, and Woodford. I humbly ask for your vote. I also humbly ask you to tell your friends, tell your family, tell your colleagues about my race. Tell them how important it is for the citizens of Kentucky to elect the most qualified person for this position. Upon election to the Kentucky Supreme Court, I will be the first woman and only the 5th person in history to have served at all 4 levels of Kentucky's judiciary. Again, I humbly ask for your vote, and I also asked you to join Team Goodwine for Justice. You can visit us on all social media sites and on our website.
Well, I'd like to thank you for coming by today. I know our viewers appreciate hearing from you. Judge Goodwine is a candidate for the Kentucky Supreme Court. Remember to get out and vote on Tuesday, November 5th, and then tune in to Channel 10 for the election results from the county clerk's office. It's election season, so become involved, vote your choice, and we'll see you next time.